The State Ethics Commission public meeting is on January 28, 2015. First, I'd like to read the executive session announcement that I must make. Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to said executive session or at the next meeting thereafter. An executive meeting was held on January 27, 2015 to review matters that are by statute 65 PACS 708-1108 confidential, including the review of completed investigations for the purpose of issuing final adjudications, the review and consideration of applications for 90-day extensions of investigations filed by the investigative division, and to discuss internal commission procedures. An executive teleconference meeting was held on December 3rd, 2014 to review matters that are by statute 65 Pennsylvania CS 708-1107 confidential, including the review of a confidential opinion request and to discuss internal commission procedures. Before we begin the meeting, I'd like to just have our newest member, Brian Westmoreland, just give us a brief background on what you've done.
Good morning, everyone. My name is Brian Westmoreland. I'm from the Harrisburg area. My background consists of 27 years in law enforcement. I started out as a municipal police officer, went to be a federal police officer, then I got hired by the Attorney General's office in 1988. My position in the Attorney General's office, I was a supervising narcotics agent. Then I went to the Internal Affairs Division, and then I ran the Executive Protection Detail for Governor Fisher, Papert, and also Attorney General Corbett at the time. I was appointed with Governor Corbett as a special assistant and for his 4 years, and he appointed me to the board in January 16th this year. Thank you.
Thank you, Brian. Welcome to the committee.
Thank you.
Commission. The first item is the approval of the October 1st, 2014 meeting minutes. Can I have a motion to approve the minutes?
So moved.
Second.
All those in favor signify by saying aye.
Aye.
The ayes have it. The second item on the agenda is the Witt-Lincoln opinion, and Judge Lewis, it's all yours.
Yes. This is Judge Lewis. I am going to be reporting on number 2. The facts pertaining to this advisory are as follows. The requester is Timothy J. Witt, Esquire, City Solicitor for the City of Connellsville, located in Fayette County, Pennsylvania. Attorney Witt has submitted the advisory request on behalf of the City Mayor, Greg Lincoln, and certain other individuals who are members of City Council. Factually, the City Mayor is a member of City Council. City Council meetings have at times been televised by a local cable provider. It has been proposed that the city support nonprofit organizations in the city under an arrangement which I shall refer to as the proposed arrangement, by which City Council would approve a list of nonprofit organizations located or operating within the city. Businesses or organizations could then make a donation to one of the nonprofit organizations on the list approved by City Council, after which the City Mayor would wear at a public meeting of City Council a shirt bearing the name and logo of the donor business or organization, which I shall refer to as a donor shirt. All donations would be required to be paid prior to the City Council meeting, with documentation of such payment provided to the city. All donations would be paid and given directly to the nonprofit organization, and no money or other consideration would be received or held by the city or the city mayor. Attorney Witt asked whether the proposed arrangement would result in a conflict of interest or other violation under the Ethics Act, and if not, whether there would be any safeguards or best practices that would further insulate the proposed arrangement from resulting in violations of the Ethics Act. Mr. Chair, I would suggest that this would be an appropriate time for any interested parties to speak to this matter.
You may continue.
Mr. Chair, before we if there's no one that's present that wishes to speak to this matter, before we would continue, I would suggest that this may be a time to take a brief recess from the public meeting to engage in quasi-judicial deliberations concerning this matter in executive session before we make a decision.
Do I need a motion to go into?
No.
Okay. As the chairman, let's take a brief recess and go into executive session. So I'll ask everyone to leave. We'll just be a few minutes. Thank you very much.
Mr. Chair, I have reviewed the facts and relevant statutory provisions. It is my view that the mayor's appearance at a public meeting of City Council while wearing a donor shirt would constitute an appearance or presentation undertaken in the mayor's public capacity and related to his public position, and that a payment made in recognition of the mayor wearing a donor shirt at a public meeting of City Council would constitute an honorarium prohibited by Section 1103D of the Ethics Act. Based upon my analysis and comments, I would make the following motion. I move that the holding of this commission in this matter be as follows. Mr. Gregory Lincoln and the other members of Connellsville City Council on whose behalf Attorney Witt has inquired are public officials subject to the provisions of the Ethics Act. Under the proposed arrangement, a payment made in recognition of the mayor wearing a donor shirt at a public meeting of City Council would constitute an honorarium prohibited by Section 1103D of the Ethics Act and would cause the mayor to run afoul of Section 1103D of the Ethics Act. Any additional conduct, such as, for example, urging those in attendance at the public meeting to patronize the donor business or organization, could provide additional support for the conclusion that the aforesaid payment to the nonprofit organization would constitute an honorarium. Having determined that such a payment would be a prohibited honorarium, there is no need to further address Attorney Witt's inquiry. That's my motion.
Do I have a second?
Second.
Maria Feely seconds it from Charlotte, North Carolina. All those in favor signify by saying aye.
Aye.
Nay? The ayes have it.
Thank you.
Good job, Judge.
Thank you.
The next case is the Deschler case, and Mr. Corrigan?
The facts pertaining to this appeal of advice and advisory request are as follows. The appellant is Attorney Matthew J. Deschler, and Mr. Deschler has appealed Advice of Counsel 14-544, which was issued to him on October 1st, 2014, on behalf of Victoria A. Coyle, Judith Del Tuva, Chelsea S. Halhalis, Lauren L. Spazial, and Robert G. Vadoni, each of whom is a member of the Human Relations Commission of the City of Bethlehem, which I shall refer to as the City HRC. Advice of Counsel 14-544 concluded that the aforesaid members of the City HRC are public officials subject to the Ethics Act and the regulations of this commission, and in particular the requirements for filing statements of financial interest pursuant to the Ethics Act. The advice determined that the fact that members of the City HRC are appointed by the City Mayor and City Council satisfies the first portion of the Ethics Act definition of the term public official. The advice also determined that the exclusion for members of purely advisory boards is not applicable. The advice noted that certain provisions of Article 145 of the city's codified ordinances provide the city HRC with the authority to elect to adopt particular expanded procedures, which I shall refer to as the expanded procedures. The advice concluded that the city HRC has legal authority to exercise a basic power of government, and it performs essential governmental functions. By letter dated October 31st, 2014, Mr. Deschler appealed this advice of council 14-544, citing section 145.06D of the city's codified ordinances. Mr. Deschler asserts that the maximum relief the city HRC can award a complainant is the issuance of findings of fact and a conclusion that discrimination has occurred. Mr. Deschler asserts that pursuant to Article 145 of the city's codified ordinances, the city HRC may not elect to adopt the expanded procedures unless and until City Council approves the election and appropriates funding for such procedures. Mr. Deschler argues that the City HRC and City Council have not elected to adopt the expanded procedures, and that in the absence of the adoption of such procedures, the City HRC is a purely advisory board. By letter dated November 7th, 2014, Mr. Deschler requested an advisory on behalf of Greg M. Schultz, who is a member of the City HRC. Mr. Deschler asked whether Mr. Schultz, as a member of the City HRC, would be considered a public official subject to the Ethics Act and the regulations of this commission, and in particular the requirements for filing statements of financial interests. Mr. Chairman, I would suggest that this time would be an appropriate time for any interested parties to speak on this matter.
Is there anyone here? Yes.
I am Matthew Deschler on behalf of
You want to,
Take-
My name is Matthew Deschler. I am an assistant solicitor with the City of Bethlehem in that capacity. I also serve as the solicitor to the Bethlehem HRC. I believe I've addressed I presented my arguments in the letter to the commission requesting, the letter to council requesting the advice, as well as my appeal to the commission as a whole. I'm here today in case the commission has any questions of me regarding the appeal that I may be able to address and resolve as best I can.
Mr. Deschler?
Yes, ma'am.
I just have one question, and I understand the position that this is purely an advisory board. What, if any, authority or do they have as it relates to the filing of complaints with either the State Human Relations Commission? Is it automatic deferment if once a matter is filed with them, or with the federal EEOC? I mean, do their findings, conclusions, or the initiation of a process with them have any bearing on a litigant's rights in pursuing these matters further?
My answer to that question is no. I hesitate somewhat in that, as I understand it, before my tenure as an assistant solicitor, there was one complaint filed with the Human Relations Commission. Since I've been on the job, we've had an additional complaint filed. I can't speak to the former complaint. I have really no knowledge of what happened there. As I understand it, it may have been withdrawn shortly after its filing. But with the present complaint, obviously I won't speak to the particulars, but that complaint was an employment discrimination complaint, also filed with the U.S. Equal Employment Opportunity Commission, as well as the Pennsylvania Human Relations Commission. So there was no need to engage in any kind of discussion about whether the complaint filed with our HRC was dual filed. I can tell you that it would be our practice if we received a complaint that could also be filed with the Pennsylvania Human Relations Commission to provide that or forward that complaint to the Pennsylvania Human Relations Commission. And the reason for that being is we would not want to prejudice a litigant's rights, given that we really have no authority to provide the kind of relief that I think most people filing discrimination complaints would like to file. I would say that in my private practice, I handle plaintiffs' employment discrimination work, and I would not, and I told this to our commission members in discussions, I would not advise clients to file with our HRC if they could also file with either the Pennsylvania Human Relations Commission or the EEOC, given the paucity of relief that we can provide. As I noted in my appeal, really, at this stage in our existence, all we can do is issue findings and a conclusion that discrimination has occurred. And I would imagine to most people who feel aggrieved as a result of some kind of alleged discrimination, that would not be sufficient. And I was looking through the ethics regulations before I came down here, and the act aside, just even going through the regulations, I don't see how our commission members fit into that role of a public official. For example, while a complainant could file a complaint in common pleas court after the process with our commission is exhausted, it's in no way an appeal from any kind of decision issued by our commission. It's a de novo proceeding before common pleas court. It's always available after the process with us concludes, either whether the complaint is dismissed or the findings of fact are issued. I don't see our findings or our conclusions in any way as a kind of binding decision issued by the commission, given that to whom does it bind, or who is bound by it. To me, that suggests a kind of consequence or effect to the commission's decision. Really, what we are at this point in our existence is a kind of, or the most we can do is a kind of shaming mechanism, a wag of your finger, if you will. You know, you engaged in discrimination. That's not good. I don't mean to to be jocular about that, but that's really all we can do. And if people want relief under our ordinance, they need to go to common pleas court. It's really, when we've had discussions about this, several discussions in our commission about kind of the lack of authority we have, and I think the movement among the commissioners is to not so much focus on the kind of legal relief we can provide complainants, which is basically nil, but to act as a more, as a community-oriented board, whether it's attending meetings, just participating in events that promote human relations, promote equal rights in the community, rather than focus on the 2 total complaints that we've received in our going on 4-year existence. So, with that said, we really don't have any kind of authority that would classify us as or classify the commissioners as public officials. This is not a case where the commissioners have the reserve authority to make adjudications that affect people's rights. Unless, and as I said, unless and until the city council and the commissioners, but more importantly, obviously, the city council, elect to adopt those expanded procedures and appropriate funding for the expanded procedures, our HRC simply cannot proceed pursuant to those procedures. If we could, obviously, I would have no problem acknowledging that the commissioners would be public officials. But that has not happened yet, and I can assure the commission here that it's not going to happen in the future, or in the foreseeable future. So at this point in time, all we can do is issue findings and conclusions. Those expanded procedures, they're not reserved powers. They are powers that are simply unavailable to us. Just as if the city council had never enacted the expanded procedures section in the first place. As I said in my advice, council could even if our authority were purely advisory, I mean, it is purely advisory, but even if our authority were not endowed with the option of electing the expanded procedures, city council could always come back at a later time, or could have come back at a later time and enacted the expanded procedures. The fact that we have a section in our ordinance that states that council and the HRC may at some point elect to adopt expanded procedures really is a distinction without a difference. City council could have always, at some point in time, enacted those expanded procedures. The fact that they're there in the ordinance really doesn't mean much, given that without council's concurrence with the HRC, those expanded procedures will never go into effect.
Mr. Witt, and this is just, I just want to make sure I'm clear, and if my understanding is not correct, just to say that's not correct. A person is not required to file with the local HRC before either filing with the state HRC or EEOC. Is that correct?
You are absolutely correct.
Okay.
As long...
And once they file, if one were to file with the local HRC, they could either withdraw the complaint and still file with the state or the federal body that's charged with enforcement. Is that correct?
Correct. Our ordinance deals with, first of all, employers or landlords, if you will, but more so the number comes into play with employers, where the employer has one or more employees. Now, I don't know if you're familiar with, but the state anti-discrimination statute applies to employers with 4 or more employees. The Title VII, the federal statute, applies to employers with 15 or more. The Age Discrimination and Employment Act applies to employers with 20 or more employees. So really the only time people would, I think, be advised to file with our commission is if they were protected, or if one of the protected classes of the ordinance applied to them and they worked for an employer with only 1 to 3 employees. The exception to that is that our ordinance does cover protected classes that aren't covered by either the state or federal statutes that are applicable, namely sexual orientation, gender identity, and expression, although at least the federal agency, the EEOC, is definitely taking a more assertive stance in utilizing the sex classification in Title VII to address discrimination on the basis of either sexual orientation or gender identity or expression. But the short of the answer is that no. Once a person files a complaint with us, they may withdraw it and still file with either the EEOC or the PHRC.
Thank you.
Mr. Chair, may I ask a question?
Sure.
I want to interject because you were just talking about this, so while it's kind of fresh in our mind, if you could look at the ordinance in it's page 7 in the materials, at the top it says Article 145, page 7 in particular. And this would be right above where it talks about the expanded procedures. And the paragraph I'm going to ask you to look at is paragraph E, option of the commission to elect for expanded procedures. I'm just going to read the first few sentences and then I have a question for you. It says, the commission shall have the authority to elect to adopt expanded procedures as set forth in subsection F of this section, subject to approval by city council and appropriation of funding by city council for such procedures. Now, the next sentence, a majority of commission members must vote in favor of adopting expanded procedures in order for such procedures to be adopted. Frankly, I find this a little confusing. I've gone back and forth on this myself. You're saying, well, city council could always have come back even without this and given them expanded procedures. My question for you is, having adopted this ordinance where they say it has to basically be triggered by a vote of your commissioners, hasn't city council delegated to them that authority to start the mechanism? Having passed this ordinance, hasn't city council given up its authority to your commission and said, hey, this is only going to happen if you vote to take these on? That's the reality of what you have right now, not what could have happened.
I still think that's illusory. For example, city council could, at the next meeting or at the second reading, pass an ordinance that repeals Section E, and then at the next session, simply pass another ordinance which adopts expanded procedures. Again, this is kind of I think it's a lot of this is just semantics. Council could, like I just said, remove Section E, then insert a provision in Article 145 that says, now, HRC, you must proceed pursuant to expanded procedures. So again, I think the fact that this ordinance in parts, frankly, is perhaps awkwardly worded, doesn't negate the reality that it is city council that must act to approve the expanded procedures. And I think that fact is incontrovertible.
It is, that is, but it seems to me on this point that at this moment in time, under your existing law, your commission members have to take action before we even get to city council. And if they don't do that, nothing happens. And if they do it, then we get to city council. It seems like it's an action of a governmental entity that I felt was beyond purely advisory. Of course, that'll be for the commission to decide. My other question for you on the EEOC. If, and not couching your answer in terms of what has happened under the two that have been received, but as a matter of law, if someone files with your commission today, does that satisfy the dual filing requirement? I mean, the second part of it.
I cannot answer that definitively. We would forward a complaint on to the PHRC if the PHRC would also have jurisdiction. My interpretation of our ordinance, reading it in conjunction with the Pennsylvania Human Relations Act, would yield a response that yes, there is dual filing between our HRC and the PHRC. I can tell you that we've had a visit from a representative of the HRC who's not convinced of that. He's kind of on the fence. So we would definitely forward complaints on if they applied, or sorry, if the Pennsylvania Human Relations Act also applied. In the one complaint that we've received since I've been a solicitor, obviously I said that the complaint was also filed with the PHRC and the EEOC, so there is no need to do that. But we would forward complaints along. The question of whether, once you file with us, you've also dual filed with the PHRC if the PHRA applies, my answer would be that would be the case. I would read the ordinance in conjunction with the PHRA to that effect, but I could not say with any kind of definitiveness that necessarily is the case. So that's my kind of roundabout answer. I think, you know, and going back to your other point, you know, again, and I don't know if Section E would preclude council from acting first and then the commission acting. Certainly they both have to act to adopt expanded procedures, but even so, I would disagree that the action of the commission to elect to adopt expanded procedures is indicative of the commission, of the commissioners having the status of being public officials, because all they have done at that point is say to city council, okay, now the question of whether we can have expanded procedures is on the table. Council, it's now your decision.
But isn't the authority to participate as an essential part, an essential decision maker in the process where you have two of them, isn't being one of them actually performing a governmental function? Regardless of who acts first, I read it as being your commission is the trigger, but regardless of who acts first, if action under this ordinance requires both of them to take, you know, some action for the expanded procedures to occur, aren't both of them acting as a governmental entity?
But it would be the adoption and placing into effect of the expanded procedures that would make the commissioners public officials. Prior to that point in time, I don't think any kind of actions that the commissioners take leading up to that would be indicative of their status as public officials. Until you have a commission that is capable of making adjudications that actually affect the rights of the people who come before them, I don't think you can say that the commissioners are public officials.
But you did say a little bit ago on the EEOC point that you do think we're, that the HRA and EEOC, that if the state HRC has jurisdiction over whatever the matter is, that filing with your commission does satisfy a legal requirement for dual filing.
We would read in that such, we would read it in that fashion. We would also forward the complaint as promptly as we can to the PHRC. But it's really not a question of how we view ourselves. It is my hope that the PHRC would view the filing of a complaint with us as also satisfying the obligation to file a complaint with the PHRC within the 180-day or 300-day timeline.
But in this proceeding, you're the one supplying the facts, so how you view yourself actually can be quite relevant to this commission, which isn't going out and doing an independent investigation. They're relying on you as the requester to supply all of the material facts that they need to make their decision. That's your burden.
Correct.
In an advisory process.
And even if the filing of a complaint with our commission were a dual filing with the PHRC, that would not affect in any way the duties and obligations of the commissioners themselves. That would just be an effect of the ordinance. Similar to the right of a complainant to take his case to common pleas court. Now, the ordinance, I'm not disputing that our ordinance has teeth. If you were discriminated against in the city of Bethlehem, ultimately, you can file a lawsuit in Northampton County Common Pleas Court and make your case that you were discriminated against. So the ordinance itself does have some bite, and it may act as a way of dual filing wherein a person who files a complaint with us may, if considered so by the PHRC, also be filing a complaint with the PHRC. But that's how the ordinance works. It sort of bypasses the actual functions and duties of the commission members. The commission members aren't involved in whether a complaint filed with us is also dual filed with the Pennsylvania Human Relations Commission. Our commissioners aren't involved in whether a complaint is filed in the Court of Common Pleas of Northampton County. So the ordinance itself, it does have some power, some bite, but that's irrespective of the actual functions and duties of the commissioners themselves.
So your position is that until council passes the expanded powers, they're not public officials?
Correct. And if council did so, I would definitely concede they would be public
You don't
officials.
argue at that point?
No, absolutely not.
Anybody else have a question?
Robin covered that. Mr. Chairman, I would suggest we take a recess again for a few moments and have a little bit of a chat.
Thank you very much.
Thank you.
The commission has asked if you could explain more fully what a dual filing requirement entails and how filing with your commission does or does not satisfy that for any given case.
It is my interpretation, and I stress that, and not just to kind of avoid the issue, but because ultimately this is, what matters is what the PHRC thinks. When you read, there's a certain section in the Pennsylvania Human Relations Act that permits municipalities to create analog human relations commissions. And the way I read the PHRC is that when you create this local analog, and they are working together towards the same ends, to eliminate and redress discrimination. A filing with a local HRC would also be, assuming that the PHRC would also have jurisdiction, a filing with the local HRC would serve as a filing with the PHRC such that the complainant would not have to separately file with the PHRC. Again, we've actually had a visit from a hearing officer from the PHRC who was on the fence, if not doubtful, that that was the case. He had some concern that a filing with us, even if the PHRC also had jurisdiction, would not necessarily be a dual filing with the PHRC, which is why I emphasize that I have, I suppose, a more comprehensive view in terms of the way the PHRC and our ordinance work, should work together, which is what I think the General Assembly contemplated when they created a section in the PHRA, which provides for local municipalities' right to form their own HRC analogs. So again, it's my contention that a filing with us, if the PHRC also had jurisdiction, should serve as a dual filing with the PHRC. That would be my hope. Obviously, we never had to address that issue because our recent filing, the only one we have currently under consideration, was also filed with the EEOC and the PHRC. And again, if there is dual filing, that would just be a dual filing by operation of law. There's something that our commissioners would do to make it a dual filing. Simply by filing with us, it would be my interpretation that under our ordinance, under the PHRC, that filing with our HRC would also be a filing with the PHRC.
Just one follow-up on that, if I may. Do you think your commission is unique when compared to the other municipal HRCs? Or if this commission rules that your commission doesn't have to file, does that mean none of them do?
I suppose if our commission and if other commissions have similar, which is essentially no public authority or no power of the state like I believe ours does, then the answer would be yes, they would not have to file statements of financial interest. I believe, I haven't checked it recently, but for example, I believe that Allentown has a more extensive ordinance which provides for some enforcement authority. I'm sure Philadelphia does. But if other municipalities have HRCs like ours, where their authority is limited to issuing a finding and conclusion that discrimination has occurred, then my answer would be yes, that they would not have to file SOPs because they would not be public officials.
Okay,
Thank you.
Continue.
continue, Mr. Corrigan.
Mr. Chair, I have reviewed the facts and the relevant statutory provisions. As noted by advice of counsel 14-544, the fact that members of the city HRC are appointed by the city mayor and city council satisfies the first portion of the Ethics Act's definition of the term public official. However, in reviewing the pertinent provisions of Article 145 of the city codified ordinances, it is my view that the members of the city HRC, on whose behalf Mr. Deschler has inquired, would currently fall within the statutory exclusion for members of a purely advisory boards. While the city HRC currently has authority to issue findings of fact and a conclusion that discrimination has occurred, such authority in and of itself appears to have no legal effect. It is my view that by itself such authority is in the nature of a recommendation. It is my belief that the only non-advisory functions of the city HRC are functions that could be performed pursuant to the expanded procedures. Based upon the submitted fact that the city HRC and the city council have not elected to adopt the expanded procedures, it is my view that the city HRC is currently a purely advisory board, and therefore the exclusion for members of purely advisory boards is applicable to the members of the city HRC on whose behalf Mr. Deschler has inquired. However, if the city HRC and the city council would elect to adopt the expanded procedures, the city HRC would no longer be an advisory board, and the exclusion for members of advisory boards would no longer be applicable. Based upon my analysis and comments, I would like to make the following motion. I move that the holding of this commission in this matter be as follows. Based upon the submitted facts, Victoria A. Coyle, Judith Deltuva, Chelsea S. Hahalas, Greg M. Schultz, Lauren L. Spazial, and Robert G. Vadoni in their capacity as members of the city HRC currently are not public officials subject to the Ethics Act or the regulations of this commission, and therefore they are not required to file the statements of financial interest pursuant to the Ethics Act. The appeal is granted. Advice of counsel 14-544 is reversed.
Motion's been made, can I have a second?
Second.
Second by Roger. Any questions? Do we need a roll call vote? Melanie?
Aye.
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 Motion passes.
Aye.
Maria?
Oh, Maria, I forgot about you.
Aye, aye.
Catherine.
And Judge Lewis, sorry about that. I don't see you guys here, so,
I was sorry, Rick.
but anyway, sorry about that.
We're listening though, we're listening.
The motion passes.
Thank you very much.
You're welcome.
Somebody left Kathy.
Item number 4, Judge Lewis, you're pretty busy today, you and Mark.
I am telling you. Well,
You
item
go for
number
6 months,
4,
that's what happened. You have Marie Feely and Judge Lewis. Actually, it's Judge Lewis on number 4.
Chair,
Go ahead,
did you
Judge.
want to?
item number 4, there are 2 civil penalty cases
I'm
with
sorry.
proposed consent agreements.
Hey, hold on a second.
You have people here on the gaming matter, I didn't, sometimes you take them out of order to
Okay,
accommodate
we can
with.
do that. That would be,
Item 7.
Mr. Nick has item 7, which is the Doherty-Snyder determination, Gaming Act matter. Roger?
The subject of this request is Stephen T. Snyder. Mr. Snyder is represented by his attorney, James A. Doherty III, and they are both present. Mr. Snyder presently serves as vice chairman of the board of the Coomru Township Authority, which I shall refer to as the authority. Mr. Doherty has submitted a copy of the authority's articles of incorporation and related documents. All of Mr. Snyder's and Mr. Doherty's submissions have been provided to all of the commissioners. In a private capacity, Mr. Snyder currently holds the position of Senior Vice President of Corporate Development with Gaming and Leisure Properties Incorporated. Mr. Snyder is currently seeking a principal gaming license from the Pennsylvania Gaming Control Board. The Pennsylvania Gaming Control Board has requested that Mr. Snyder seek a determination from the commission pursuant to 4 Pennsylvania Consolidated Statutes, sections 1512A51, as to whether his position as the vice chairman of the authority board would bring him within the definition of the term public official as set forth in the Gaming Act. Per the submitted facts, the authority is a self-funded municipal authority, which acquires operational funds through the collection of user fees and associated charges, as well as independent developer fees. There is no revenue from either the Commonwealth of Pennsylvania or Coomru Township that is received by or passes through any of the authority's accounts. The authority does not receive any revenue generated from taxes derived from gaming revenues or distributions of any funds generated through gaming or gaming-related activities. And as vice chairman of the authority, Mr. Snyder is not involved in the development of regulation or policy relating to a licensed entity and is not involved in any other matters under the Gaming Act. Mr. Chairman, I would suggest that this would be the appropriate time for any interested parties to speak on this matter.
Good morning. Thank you, members of the commission. My name is Jim Doherty. I'm here today with my client, Mr. Snyder. Everything Commissioner Nick has recited is exactly our position. We believe that Mr. Snyder does not qualify as a public official, as that term has been defined under the Gaming Act. We've rested on our submissions today. Unless the commission has any questions for myself or Mr. Snyder, we'd be happy to respond to them. But with that, we rely simply on the submissions to your office.
Any questions? Very good.
Thank you.
Mr. Chairman, I reviewed the facts and the relevant statutory provisions. None of the 5 numbered paragraphs in the Gaming Act's definition of the term public official would apply to Mr. Snyder. Paragraphs 1 and 2 of the definition would not apply to Mr. Snyder because they list particular public positions that he does not hold. Paragraphs 3 and 4 of the definition would not apply to Mr. Snyder because, based upon the submitted facts, the authority does not directly receive a distribution of revenue under the Gaming Act. Paragraph 5 of the definition would not apply to Mr. Schneider because based upon the submitted facts, as vice chairman of the authority, Mr. Schneider is not involved in the development of regulation or policy relating to a licensed entity and is not involved in other matters under the Gaming Act. Given my analysis and comments, I would like to make the following motion. I move that the holding of this commission in this matter be as follows. Based upon the submitted facts, the service of Stephen T. Snyder as vice chairman of the board of the Cumru Township Authority would not bring him within the definition of the term public official as set forth in section 1512B of the Pennsylvania Racehorse Development and Gaming Act, and therefore it would not cause him to be subject to the restrictions of section 1502A, A1, and A2 of the Gaming Act. That's my motion.
Motion's
Second.
been made, do I have a second?
Second.
Second.
All those in favor signify by saying aye.
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 Nay? Ayes have it. Okay, let's go to item 4. Judge Lewis, this deals with the civil penalties order of 2 individuals, Lansinger and Avila.
There are 2 civil penalty cases with proposed consent agreements that are now before this commission for decision. These 2 cases involve respondents Eric Lansinger and Janine Avila. The parties have submitted consent agreements proposing that the commission find that the respective respondent failed to file timely statements of financial interest for calendar year 2013 and impose 1 civil penalty. The agreements also proposed a imposition of the assessment of cost against each of these respondents.
Excuse
In
me,
each
Judge.
case, the respondent has not paid
Judge,
the
Judge,
settlement
hold on a
amount
second,
agreed to
Judge.
by the parties per the consent agreement, or filed the,
Judge Lewis,
yes.
Rob wanted to speak.
In regards to the part of the agreement where there was going to be the imposition of costs, I've asked Brian to, as representing the legal division, to make a, the investigative division, to make a verbal motion to the commission to withdraw the investigative division's position on the $100 costs.
That would be correct. We would make an oral motion at this time to withdraw the portion of the consent agreements regarding the $100 cost in each of the matters, but to proceed with a $250 civil penalty as negotiated between the parties. Essentially, instead of $350 total, that would be due to the commission and the Commonwealth of Pennsylvania would only be $250. This is in line with other consent agreements that have been issued by this commission in the past.
And Mr. Chair, even though I don't think the other parties are present, since that would be to their advantage, it would be a non-justiciable issue for them, and I think it would be appropriate that you could grant that motion if you wished.
So, well, I'll make the motion to approve that request. And-
I would second.
Okay, Judge Lewis seconds it. Any questions? All those in favor signify by saying aye.
Aye.
Nay? The ayes have it. Very good, thank you.
All
You
right.
may proceed, Judge Lewis.
All righty. In each case, the respondent has not paid the settlement amount agreed to by the parties per the consent agreement or filed the delinquent statements of financial interest. Based upon my review of the facts, I am of the opinion that these consent agreements, as modified by the motion which was just adopted, are consistent with the Commission's precedent in such cases. Based upon my analysis and comments, I would like to make the following motion. I move that this Commission approve the consent agreement submitted by the Investigative Division as modified by the amendments, and that respondents Eric Lansinger and Janine Avila, and in each case, levy against the respondent a civil penalty in the total amount of $250 for failure to timely file a statement of financial interest for calendar year 2013. I further move that each of these respondents shall be ordered to pay the $250 civil penalty to the commission within 30 days of the issuance of the commission's order. Further, each of these respondents shall be ordered to file a complete and accurate statement of financial interest for calendar year 2013 with the Pennsylvania Department of Public Welfare, and to forward one copy of such filing to this commission for compliance verification purposes within 30 days of the issuance of the commission's order.
Very good.
Second.
Second was made by Mark Corrigan. Any questions?
Question.
All those in favor of the motion, say aye.
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 The ayes have it. All everyone's voted for. Item number 5, the matter of civil penalty orders defaults. Roger, Nick.
Thank you, Mr. Chairman. There are 9 civil penalty default cases that are now before this commission for decision. These cases involve the following respondents: Renee Howard, Susan McLaughlin, Jane Adams, Sherry Ann Bryson, Karen Charleston, Tony Sinsot, Kimberly DeLoach, Sean McGee, and Luz Velaz. Respondents Howard and McLaughlin each failed to file a statement of financial interest for calendar year 2012. The other 7 respondents each failed to file a statement of financial interest for calendar year 2013. These respondents did not take action or respond to the civil penalty proceedings. Following review, it is my opinion that as to each of these respondents, the commission shall levy a maximum civil penalty of $250 for the delinquent statement of financial interest. It is my opinion that the commission should also order these respondents to file their delinquent statements of financial interest. There is nothing of record that would constitute a defense or excuse for their noncompliance. Based upon my analysis and comments, I would like to make the following motion. I move that this commission levy a maximum civil penalty in the total amount of $250 against each of the following respondents for failing to file a statement of financial interest for the respective calendar year. Renee Howard, calendar year 2012. Susan McLaughlin, calendar year 2012. Jane Adams, calendar year 2013. Sherry Ann Bryson, calendar year 2013. Karen Charleston, calendar year 2013. Tony Sinsot, calendar year 2013. Kimberly DeLoach, calendar year 2013. Sean McGee, calendar year 2013. And Luz Velez, calendar year 2013. Further, these respondents shall be ordered to file their statement of financial interest for the year stated within 30 days of issuance of the commission's order.
Do you have a second?
Second.
Ron Westmoreland seconds it. Any questions? All those in favor signify by saying aye.
Aye.
The ayes have it. Very good, Roger. Item 6 is the lobbying disclosure law administrative penalty orders, and Mr. Corrigan.
There are 10 administrative penalty cases with proposed consent agreements for our consideration. The following respondents are principals that failed to timely file a quarterly expense report for the second quarter of 2014 in their capacities as registered principals. Big Brothers and Big Sisters State Association of Pennsylvania, Nueva Esperanza Incorporated, Big Brothers, Big Sisters of Southeast Pennsylvania, Shura Development Incorporated, Pennsylvania Association of Mutual Insurance Companies, Pennsylvania Automotive Recycling Trade Society, American Association of Diabetes Educators, Pittsburgh Opera Incorporated, Three Click Solutions, and Pocket Pets. In each case, the parties are in agreement that the respondent's transgression of the lobbying disclosure law was negligent. Respondents Nueva Esperanza Incorporated, Shura Development, and the Pennsylvania Association of Mutual Insurance Companies have already paid the agreed-upon administrative penalties and cost reimbursements and have filed their delinquent expense reports. None of the other respondents have paid the agreed-upon administrative penalties and cost reimbursements, but all of them, except the Pittsburgh Opera Incorporated, have filed the delinquent expense reports.
Excuse me, Mr. Corrigan, even the Pittsburgh Opera has now, everyone has filed their delinquent reports,
Oh,
we just checked on that.
It just came in, okay, so we'll delete that sentence. Based upon my review of the facts, I'm of the opinion that the consent agreements are proper dispositions of the respective cases, and I would like to make the following motion. I move that the commission approve the consent agreements submitted by the investigative division and each of the following respondents, and impose the following administrative penalties. As to Big Brothers Big Sisters State Association of Pennsylvania, Nueva Esperanza Incorporated, Big Brothers Big Sisters of Southeast Pennsylvania, Sherrod Development Incorporated, the Association of Mutual Insurance Companies, Automotive Recycling Trade Society, American Association of Diabetes Educators, Pittsburgh Opera, and 3 Click Solutions, 1 administrative penalty each in the amount of $2,695 for their delinquent expense reports for the second quarter of 2014. As to Pocket Pets, 1 administrative penalty in the amount of $1,470 for its delinquent expense report for the second quarter of 2014. I further move that each of the aforesaid respondents are directed to pay the agreed-upon additional $250 payments to be made to the Commission, representing a portion of the costs incurred by the Commission in the investigation and enforcement of their respective matters. Finally, I move that those respondents who have not yet paid the administrative penalty or additional payment of $250 for the second quarter of 200 are directed to do so within 30 days of the mailing date of the Commission's order.
Motion's been made, do I have a second? Melanie?
Second.
Melanie seconds.
Question, Mr. Chairman.
I'm sorry.
Do we keep track of whether or not any lobbyists are recidivists in this type of conduct?
Yes, we do.
And do we make note of that when we have these?
Yes, we haven't had any recidivists yet.
We haven't, okay.
We have not yet, we've been pretty lucky.
Okay. That's all.
Okay, the motion's been made, and it was seconded. All those in favor signify by saying aye.
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 Nay. The ayes have it.
And I just want to make clear that I had to recuse myself because of some of the entities here for this one.
Okay,
Maria, for purposes of the orders, you recused yourself from 2 that I know of. Did you vote as to the
Right.
others?
yeah, she
Right,
does.
so the Pennsylvania Association of Mutual Insurance Companies and the American Association of Diabetes Educators.
So only as to those 2 that you recused.
Let me read a notice of a special election pursuant to Commission Resolution 85-002. A notice of special election must be publicly announced at least 30 days prior to such election and forwarded to all members of the commission. Therefore, the Pennsylvania State Ethics Commission hereby announces that a special election will be conducted at the next regularly scheduled meeting of the Pennsylvania State Ethics Commission for the purpose of selecting a vice chairperson. The commission member so elected shall serve the unexpired term of Commission Chairman Victor Colifield, who has assumed the position of Commission Chairman as the result of the expiration of the term of service of former Chairman Charles A. Bolger. The term of office for the vice chairperson will expire on April 25th, 2016. Yes,
I'll have one other matter before you adjourn.
okay. That's it.
Okay. It's been brought to my attention that in the matter of Pocket Pets, which the commission had just ruled upon, the consent agreement additionally called for, by the parties' agreement, that Pocket Pets would refrain from any and all lobbying activities in Pennsylvania until December 31, 2019, which the parties considered to be tantamount to a ban on lobbying in Pennsylvania until that date. That's something that would need to be included in the order, and I would just ask that the commission have an additional motion to add that to the order. It's something the parties are free to agree to do, and in this case, they have done that.
I would so move and amend my original motion.
Just a second.
Second.
All those in favor signify by saying aye.
Aye.
Nay. The ayes have it. Very good. I think that's it. Thank you very much. I think it was a pretty good meeting and some very complex issues.
Are you gonna introduce the intern?
Yes.